Voting rights leaders view the Supreme Court's current conservative makeup as hostile to the Voting Rights Act. A federal appeals court on Monday moved to dramatically weaken the Voting Rights Act, issuing a decision that would effectively block private citizens and civil rights groups from suing. Under a central provision of the landmark civil rights law, the ruling by the 8th U.S. Circuit Court Appeals found only the federal government can raise a legal challenge under Section 2 of the Voting Rights Act, a key piece legislation that bans election and voting practices discriminate against Americans. The opinion is almost certain to be appealed to the Supreme Court. The court's current conservative majority has issued several landmark decisions in recent years that have weakened the Voting Rights Act, but justices have upheld the law in other cases, including a decision in June that found Alabama had drawn a racially discriminatory congressional map. The Voting Rights Act, passed in 1965, was one of the most significant achievements of the civil rights movement. It repealed decades discriminatory Jim Crow laws and protected against horrific racist gerrymanders. But law has been under legal attack almost since its inception, and court decisions over years have gutted key provisions, including requirement that states with a history of voting discrimination get approval from federal government before changing their voting laws. Monday's decision from 8th Circuit, which focused on a case in Arkansas, found that text Voting Rights Act does not explicitly contain language about a private right of action, or right private citizens to sue under law. Therefore, court concluded that the right to sue would effectively rest with government alone. If decision stands, perhaps the most important aspect of Voting Rights Act will be eliminated. Most objections to discriminatory laws and racial gerrymandering came from private citizens and civil rights groups. If it remains law, it would be a devastating near-death blow to Voting Rights Act, said Wendy Weiser, director of the Democracy Program at Brennan Center for Justice. Radical theories that would previously have been laughed at in court are being taken increasingly seriously by an increasingly radicalized judiciary. But Weiser said he would be surprised if this decision holds, based on decades of legal precedent and recent Supreme Court decisions. Section 2 of the Voting Rights Act is at the center of many civil rights and voting rights decisions. The lawsuit over the Supreme Court's decision against the Alabama map in June was filed by a number of civil rights organizations. This section was also used to challenge the strict voter identification law passed in Texas in 2013. Some conservative legal scholars heralded Monday's decision, saying it would prevent the Voting Rights Act from being used for political purposes. Today's decision is a victory for Arkansas and the rule of law, said Jason Snead, X.